Thanks very much, Anne, for the introduction and for the opportunity to tell you a little bit this evening about Temple Heelis and the work we do advising clients in the local area. Anne's given a little bit of our history away. Obviously, our most famous predecessor was William Heelis. But like a lot of solicitors' firms, we're an amalgamation of a number of local firms that came together. Mr. Heelis's practice, he was actually the last in a number of Heelises, he didn't have any children, and the practice was sold, and Gatey Heelis was formed as a practice in the Windermere, Ambleside, Hawkshead area. And in the late 20th century, we merged with Temple and Barge, which was a Kendal law firm, to form Temple Heelis, as we now are. We cover most of the areas of practice I think you'd expect from a local high street solicitors firm. We do quite a lot of commercial property work to do with hotels, guest houses, that kind of thing, I should imagine, from the area that we're in. Usual family and divorce, litigation, lots of property disputes, boundary disputes, farmers getting upset with each other, that kind of thing. Employment disputes, particularly, we're often out for employers in that. My area, which I'm going to tell you a little bit about tonight, is wills, trusts and probate, which is nowadays tends to be known as private client work, and we do a great deal of residential conveyancing. So I'm going to tell you a little bit about what my work is like as a lawyer dealing with wills. Well, a will is the only document, when you think about it, by which you can dispose of everything you own, the entirety of your estate. And so it's a very important document. And it serves a number of purposes. It's obviously a very technical document at times and can be written in quite technical language. But at the same time as that, it's a very personal document as well. It's the document whereby you can dispose of your jewellery, your personal possessions, and it's a very wide-ranging instrument that can cover everything that you own. So it's one of those things that everybody puts off, but it's also one of those things that we should all get around to doing. And what is a will? My children think I just sit in the office all day long and write lists of who's going to get the train set, this, that and the other and what have you. But it's not just a list of who gets what. And a great deal of what we spend our time advising on is actually tax considerations. And depending on circumstances, there can be quite a lot that some people can do to actually minimise the amount of tax they pay on their death. And that's a big motivation for a lot of our clients coming to see us. Family considerations, again, another key area, and it's probably true to say that the more complex the family situation, then sometimes the more complex the will has to be. And depending on people's situations, we can often need quite a number of meetings to work out what the best thing to do is in a particular situation. And it's very much a joint effort by the solicitor and the client. We have a number of approaches. Some clients coming to see us. Sometimes a client will come in and say, this is what I want to do, you reduce it into a document and I'll sign it. And sometimes we have to bring those clients around a little bit to perhaps persuade them that what they had in mind wasn't necessarily the best way forward and coax them into something a little bit different. Other clients don't know what to do and they say to me things like, well, what would you do? And so we have to say, well, you know your family better than I do. We can give the benefit of our experience, but we'll try and help them to come to what is the best situation in their family. But it's a case of working with the client, relying on them to do their bit. We're just the advisors. In terms of some of the things that we have to deal with on an everyday basis, I've put capacity at the top of there. I know we've got a doctor in to hear from tonight, and I think that capacity is a big thing that we have to face all the time. Does the person signing a will understand what they're signing? And sometimes we have the tricky business of actually saying to somebody, we're doubtful about your capacity. We're not sure whether you can sign this, and that is a very difficult area to deal with. But when we do a bridge we have to cross. And undue influence is another area, Are the relatives saying, I won't look after you in your old age unless I get this, that and the other under the will? And things, maybe not quite that extreme, but those sort of things do go on. I put children and animals together. Often when I walk into the waiting room, if it's a new client, if it's a married couple there and I think, least they're the age where probably their children are grown up. At least I know we don't have to face that conversation about who the guardians are going to be. But I've seen more arguments in front of me between husband and wife over that than anything really to do with the money. And animals. Some people, when they're coming to make a will, their real number one consideration is who's going to look after the dog when I'm not here anymore. And other things we have to deal with. Domicile and residence. Some of our clients have always lived in this country, very straightforward circumstances, but more and more often there's people with foreign spouses, people that have moved into this area. There's lots of things to think about. Where should their will be made? Should it be in England? Should they be making a foreign will? Do they need more than one will? And then there's different kinds of wills. I think people think that a will is very rigid. It says, leave a legacy of so much which the grandchildren and the rest split between 3 ways between the 3 children and what have you. But wills aren't always that rigid. Sometimes they're contingent. They say somebody will get something, but only if something else happens, like he survives to age 25 or whatever the requirement is. And if that doesn't happen, then something else will happen. And some people's wills are what we call discretionary. You leave it up to the trustees to decide what's going to happen afterwards, which is in one sense unsatisfactory, but some people's circumstances are such that they can't at the time they make their will decide what's going to happen, and they have to make the decision. The trustees are going to be appointed later on to make those decisions for them. Foreign aspect. Well, one of the things I've noticed in the years since I qualified is how many more people own a property overseas. It was quite unusual when I first qualified, and all these holiday programs, Kirsty Allsop and whatever it is, place in the sun, a lot more people have got their villa in France, apartment in Spain, what have you. And so that creates a situation where people might need a will in more than one jurisdiction. And then you've got problems with potential clashing, and making sure that you don't sort of have a situation where property in certain countries isn't covered by your will. And that other problem with, you say, I hereby revoke all my previous wills, and you accidentally revoke the will you've made in Spain, which wasn't intended to be revoked. So where people have got foreign property, that's definitely an area where they need to have some specific advice. After somebody's passed away, we have to deal with the estate. It can be small or large, simple or complex, and we see a wide variety of estates. Our clients will be the executors, who are the people whose job it is to carry out the terms of the will, and to obtain probate, which is the official document from the court which gives them the authority to administer the estate. And that would be our job, to assist them in doing that. And if you don't have a will, well, it's an intestacy, and then the government sets the rules as to who would inherit in those circumstances, and we would advise the clients in relation to that. And one thing I've just mentioned here, claims arising after somebody's died. You know, you will hear about this, challenges against a will, somebody claiming that adequate provision wasn't made for them in a will. And there's quite a lot of time periods in which such a claim can be made. You often hear the complaint, oh, my solicitor took months and months and months to deal with the estate. But it may just be that what's happening is they're waiting for these periods to pass by, during which somebody would have the chance to make a claim against an estate before they finalise administration. After death, inheritance tax has to be paid. There's various exemptions for spouses and charities, amounts of the estate that are charged at nil, and then there's a big 40% tax on the rest. Farmers, business owners, special treatment, so there's quite a lot of things to think about in the administration of an estate. And if you just move on to the next slide. One other thing I thought we'd mention is not to do with estates as such, but incapacitated people. More and more we are having to advise families and individuals in relation to elderly people who lose their capacity. That involves making a power of attorney while the person's still got capacity, so that they've got arrangements in place to cover both their property and finances and health and welfare decisions if they were to suffer an event where they didn't have capacity in the future. And we have roles in assisting clients with that, and if somebody hasn't made a power of attorney, then it might be necessary to go to the court of protection to get a court order appointing somebody to deal with their affairs. And again, we're spending more and more time dealing with that kind of thing. So in terms of the work that I do and that my colleagues do, I think it's comes with a lot of responsibility. There's quite a lot of risk, I think, involved at times, because you're dealing with complex and difficult issues, but it's definitely a very rewarding job. And when it goes well, we often become the trusted advisor to that client, who will then come back to us regularly and ask us to be the people that helps them make important decisions regarding their family finances and estates. So that gives you some idea of what we do, but if anyone's got any questions, I'd be happy to take any questions.
After the death of the testator, you said that there's a time period where people can make a claim against the estate. What is the time period, and on what basis can anyone claim against the estate if they're not in the will?
Well, okay, so there's two types of claims. So there's certain types of claim that is questioning the validity of the will, okay? But I think the type of claim that I was particularly referring to there is not where the will itself is being challenged, but it's where the suggestion is the will doesn't make provision for somebody who needs to be provided for. So, for instance, if you've got young children and you make a will that doesn't benefit them, well, you've got a responsibility to those children after you've died as well as while you're alive. There's also the principle that you shouldn't be any worse off because your spouse has died than had you divorced. Okay, so if you're a wife that doesn't benefit under the will because it's all being left to the mistress or whatever, then you'd have a claim. And the basic, the long stop period is basically 10 months after the probate has been granted as the absolute period during which you would really delay the administration for those kind of claims. Obviously, if the claim turns up, well, who knows how long that would then take to resolve.
Thank you, Jamie.
Yeah. Thank you very much.